Welcome. If you haven't gotten anything to eat, please do so. There's lovely gourmet pizza in the hallway. My name is Sharon Holland, and I'm in the Departments of English, African and African American Studies, and Women's Studies here at Duke. It's my pleasure to be moderator of our panel today, Second Parent Adoption, Post-Amendment 1. I want to thank Brandon and Haley for helping me to organize this, and all of you for showing up on this very rainy, sleety day. I'm going to introduce our panelists in the order in which they're going to speak, and then they're going to speak for 10, 15 minutes each, and then we'll open it up for conversation. Caitlin Breedlove has been a co-director of Southerners on New Ground Song, which many of you might know, since 2006. Song is a home for LGBT liberation across lines of race, class, abilities, age, culture, gender, and sexuality in the South. Song builds, sustains, and connects the Southern regional base of LGBTQ people in order to transform the region through strategic projects and campaigns developed in response to the current conditions in our communities. Caitlin was the intern program coordinator at the historic Highlander Center in Tennessee before coming to Song. She is a second-generation immigrant of Eastern European and queer life.
I think so, sure.
Something, right? And she lives in Goldsboro, North Carolina. She is a writer, organizer, and strategist who has been working in the South her whole adult life. Woohoo! This part of the country. Our second speaker, Sharon Thompson, who founded the practice that became Sharon Thompson Law Group in 1976. She is a seasoned family lawyer and accomplished practitioner in all aspects of estate planning and probate administration, including elder law. She has also taught at both the UNC Chapel Hill and North Carolina Central Schools of Law. She was a recipient of the North Carolina Association of Women Attorneys Annual Award in 1987, the Planned Parenthood of Raleigh Margaret Sanger Award in 1990, and the list goes on. She was a co-founder of the North Carolina Association of Women Attorneys and has served as counsel for various nonprofit organizations. Her practice includes, again, estate planning and probate administration and family law. And our final speaker, Chris Brock, joined the ACLU of North Carolina as its legal director in 2012. His practice areas correspond with ACLU's civil liberty focus, touching particularly on racial justice and LGBT issues, as well as First and Fourth Amendment concerns. In his time as ACLU legal director, he has worked to safeguard religious liberty in public schools, fought against Amendment 1, and to narrow its potential collateral consequence, and worked to protect free assembly rights in Charlotte during the Democratic National Convention. He is a member of the North Carolina Advocates for Justice Racial Justice Task Force, as well as the North Carolina Bar Association Constitutional Rights and Responsibilities section. And I just wanted to add that this gathering is being sponsored by the Center for LGBTQ Life at Duke, and also, of course, OUTLaw. Thanks again for joining us. Caitlin?
Hi, everybody. I'm happy to be here. Happy to be invited as a non-lawyer. Both my mother and sister are lawyers, and they are both public defenders, which means they are very grouchy and also very tough, and have gotten a lot of people I work with out of a lot of jams. So I totally appreciate will-be lawyers and lawyers themselves. So I want to talk a little bit about the big context just for a second when we think about the South, and then I want to talk about North Carolina and Amendment 1, and then I really am not going to talk about all the kind of legal questions around second parent adoption because I think our other two panelists could do a much better job than me. So let me just say that, you know, when we look at the trajectory and history of the LGBTQ rights movement, it's really important to not let the moment erase the complexity of the history. And so the history is that, you know, there have been amazing forces in individual communities on the ground that have been moving and agitating for more and more rights. And policy work and legal work have been a huge part of that and have flanked and supported. But it's also important to remember that so much of the push came from individual people starting to come out, starting to push in their communities, starting to say we're not going to take this anymore, and then gave opportunities for legal and policy changes to really start to happen, right? On local levels, state levels, federal levels. And a great example of that is looking at, you know, a body like the Supreme Court, right? It's not like it's just a magical glitter gets put on the Supreme Court and suddenly their positions are different than they were 15, 20 years ago, right? It's the actual change in the country, the kind of culture change, the kind of change that people on the ground are pushing that works in tandem. And sometimes, I wonder if y'all would see this as well. We notice in this work, it becomes like, well, this is the only kind of change that's important, or policy is the only thing that's important, or legal challenges are the only thing that's important, or grassroots organizers saying, no, this is the only thing that's important. And really, the reality of history reflects that's not true. These pieces don't work separately. It's actually about how we work together to make change. And when we look at the LGBT movement overall, we see that, in mainstream progressive national spaces, for good and for bad, the LGBT movement is being seen as on the rise, really making wins as we go and moving on a line of progress on multiple issues. So we could talk for a long time about the ins and outs of that and the pros and cons, but that's not actually what we're here to talk about that specifically today. But I think how that connects to the South is really important. So before we go North Carolina specific, I think it's really important to situate North Carolina in the rest of the South. So SONG is an organization with 2,500 members across the South, and most of our members are leaders themselves in local communities. So from people who are leading Black-led LGBT fraternities and sororities in really closeted places like Mississippi and Alabama, to very large organizations of LGBT people in places like Atlanta. SONG sort of creates a network and an infrastructure for leadership in a lot of different places. So we have lawyers in our base, we have artists in our base, we have total wonderful policy wonks, I say that in the best way possible, in our base. And everybody's working on some sort of different fronts of the work. But one of the things that we have seen is that with examples like Amendment 1, a lot of folks in North Carolina are not as familiar with the history of the kind of ballot measures that were brought to other states in the South. And painfully and unfortunately, I was personally there for several of them in different states. One of the great highlights personally was when I was organizing in Kentucky and dressed up as Jackie Kennedy Onassis. I was a little younger than them, to do bar outreach and work again and again. So we had some good times, and we lost again and again and again in Kentucky, in Georgia, and South Carolina. And some of those losses were very demoralizing for our base, especially because a lot of them were fights that had been brought to us that our states had not chosen. The LGBTQ communities there had not said, this is what we want to fight about. We choose gay marriage, or we choose this particular issue. They were defensive fights, if that makes sense. And so they left a wake of a lot of complexity when you're dealing with how demoralizing they are for bases of people. Given that, we want to say a little bit about Amendment 1 itself. So I do want to say that while gay marriage, for example, is a very important issue personally to a lot of LGBT people, the reality also remains that we have to think about what affects the majority of the LGBT community. Otherwise, we get ourselves a little positioned in this trickle-down situation, right? Like, well, if a certain subset of the community is able to get married, that'll trickle down to basic safety, human rights, and dignity for the rest of the community. So I think we can hold a space where SONG, with wonderful work from the ACLU and other groups, worked around Amendment 1, but while seeing this wasn't the only issue, but it was a fight that came to our backyard that we really had to engage in, right? So the reality of the work against Amendment 1 is that, what was talked about internally at the time was a lot of national pollsters said it would take 507,000 people, right? So right around 500,000 to defeat Amendment 1. So what that tells us, for folks who might know the facts, is that national pollsters often don't know a lot about the states or the South, or are making projections that, don't always fit. But for folks who know, we actually got 823,000 people to vote against Amendment 1 and still lost. A lot of folks know that was around, the timing was during a Republican primary, which is really, really hard to win during that time. But I do think it's important to also notice that in the South, we can't really just look at a short-term picture of wins and losses. While it was a painful loss in a lot of ways, looking at what happens with those 823,000 voters, what the trends might look like in the next 10 years for folks who were politicized in that work. And again, as I think the ACLU and other groups bring in, the kind of support that can be built for legal challenges is really important to look at and see. A lot of you may know quite a bit, and some of you maybe not as much, about some of the work against Amendment 1, but I think an important thing to know about the character of that work was that there was more than 170 groups in the coalition who were sort of endorsing and working against Amendment 1. And then there was a much smaller set of 8 groups, the ACLU and SONG being 2, that were in the steering committee making particular decisions. But for a group like SONG, we were both present in the steering committee and had our own separate grassroots organizing, which was focusing primarily on LGBT poor people, LGBT people of color, and LGBT immigrants. So we're both working at that level with a set of organizers and then working in the steering committee. So why does that matter, or what does that mean? Is because you're creating a space where you can be doing what's called kind of grass tops work, where you're organizing other heads of organizations, you're working within the progressive infrastructure that's built in the state, and at the same time you're building a new group of grassroots leadership that's actually challenging the national status quo that says all LGBT people have money, all LGBT people are straight white men, which has kind of been put out by the right wing, right? Which is like, you know, you don't have to worry about gay people. They're all wealthy, wealthy white men that live in Manhattan, right? And we know that that is actually working against the community. I think one really important fact for folks to think about when you talk about second parent adoption is that the New York Times did some research, and what they found was that there are more, of all of the people raising children in the LGBT community in the South, Black lesbians are among the highest %, right? And there are more Black lesbians raising children in the South than anywhere else in the country. So I just say that to really bring in race and decenter a little bit, like what we often are pushed towards seeing as the vision of adoption, right? Which is often 2 white lesbians. That's the vision. Now, there's nothing wrong with that. There are a lot of white lesbians who absolutely deserve rights, and that's very, very important. But it's also important to look at, one, how the country is changing around race and moving towards being a majority people of color country, and 2, latest statistics that talk about, actually, the Williams Institute reported recently that of all the % of out people, the majority of out people in this country are now people of color, which is a fascinating statistic on many levels, which we could talk a lot more about. Does that mean that the majority of LGBT people are folks of color? Or does it mean that the majority of people building the resiliency to be out are people of color, right? So we could break that down all kinds of different ways. But I think these are really important kind of newer statistics. The statistics I'm quoting, New York Times is 2 years ago, that Williams Institute one is in the past year. So when we think about second parent adoption, we also want to think about a wide context of sort of who are these people, right? We always want to think about with legal questions, it's always dangerous to have it be way too disconnected from actual folks' lives and what people in our communities actually need and who we're talking about. So that being said, I think it's also important when we think about issues like second parent adoption in a state like North Carolina to think about how do we make a plan even as we push for legal challenges or policy change? How do we make a plan for implementation? How do we make a plan for figuring out, if you live where I live in a place called Goldsboro, North Carolina, which I was just telling Sharon, I moved there for love some years ago, but if you live there, most of the LGBT people who live in that rural part of North Carolina, it's about an hour east of Raleigh, are very poor, are Black or Latino, are not out in any kind of verbal way, but many kind of butch or stud identified Black folks, especially women, and trans folks are just challenging the gender norms in Target or on the street or in the library by their actual gender presentation, which is something SONG has really seen in the last 5 years. It's true in our base in Atlanta, it's true in South Carolina, it's true in Goldsboro, that you have more LGBT young people who are just being like, all right, I might live in a town where if you Google gay Goldsboro, you will get nothing, right? Which I just want to hold up because we think sometimes about North Carolina in this particular way. And I know for many people in Durham, Greensboro, Raleigh, Chapel Hill, even Charlotte, Amendment 1 was a huge wake-up call about the kind of bubbles that folks are living in of privilege of those parts of the state. And there's a sort of certain vilification of rural communities that happened in that SONG thinks is fairly problematic. Because if we look at some of the sites, you know, SONG did some rural organizing, and in the places where we really concentrated, the numbers were really different. Places like Wilmington, places like Buncombe County, which, obviously that's not all rural, but looking at even Catawba County, right? Looking at different parts of counties. So all that to say that actually we can have impact, but you can't expect communities that have been devoid of resources and have actually been denied opportunities for resources for these issues to shift overnight, right? So I say all that to say, when we look at where people are actually living and how people are affected differently in a place like Hickory, North Carolina versus Durham, we also have to look at then, when we think about second parent adoption, who are we picturing? And really questioning yourself, especially like the soon-to-be lawyers, right? Like, who are you picturing? Who are you thinking about? How are we thinking about, as we're moving towards these kind of policy and legal changes, how are we thinking about what that's going to mean for folks in these other parts of the state? Who's in our mind's eye? And then how are we actually thinking about using the kind of power we're able to have, or the kind of experience and knowledge to think about how do we have a strategy so that the parents who are raising small kids in Hickory, North Carolina, this impacts them then. And the other thing I'm going to say about this is that when we talk about foster and adoption care, adoption and foster care, that we also need to talk about how patterns are different across race and class of what that looks like. So a lot of the stereotype that we've seen and the kind of mainstream vision has been, white lesbians or two white gay men adopting either white kids or kids of color from other countries. That's a visual we see a lot. The reality in a lot of the communities that Song works in is that what often happens is that in communities that are living in poverty, especially communities of color, a lot of times sisters are adopting their brother's young kids. Our board chair, for example, she has been raising her brother's 2 kids in Little Rock, Arkansas, with her partner from Brazil for many years. And now her girls are 13 and 15, right? So thinking about the Kendras and Chris's of the world, right? Those kids, it was all love in that family, but they were not going to have the home they needed with her brother, right? When you talk about the fact that 1 in 3 black men spend time in prison at some point in their life, you think about family members and non-blood family members that are stepping in. Let's really kind of complicate how we're thinking about foster care and adoption, and how we're thinking about what does it mean to think about legal challenges and laws that are going to actually protect and defend the rights of all kinds of families, because it doesn't always look like international adoption. It doesn't always look like adoption outside of families. It doesn't always look like foster care systems. Sometimes the support might look like, how do we help prove that this child, especially young kids of color, don't need to go into foster care. They can go to their aunties. They can go with their grandma. Their grandma might be real poor and could still be a much better choice than a kid being traumatized by going through the system. So I'm going to stop there, and I'm eager to hear what y'all have to say.
Good. Hello, I'm Sharon again, and it's great to be here. Not only it's great to learn from other speakers and from you all and hear what you future lawyers have to say, especially from us old lawyers. I would sort of characterize my work these days, a lot of it is in what we call family creation, which is creating families, and I leave now the family breakups to my other colleagues, and I stay with the creations, which are obviously same-sex couples who want to have children, whether women who are using donor insemination or using the eggs from one, inseminating them in the other, or gay men who are using surrogacy, or any parties using adoption, although unfortunately adoption has become rarer and rarer, particularly international adoption is almost completely not possible anymore. So I certainly work with same-sex couples, and I also work with any other couples who, in the area of surrogacy, is another becoming bigger and bigger issue. And to follow up with Caitlin's, I loved your statistics. I think the other one I thought you were going to go to is the highest percentage of gay families, gay couples raising children are in the South too. So in addition to the black families, so I think that's interesting statistic to look at, and why it's really important to care about things like second parent adoption here in this area. And certainly, obviously why parentage is important, and that's what I try to do is establish it, is same-sex couples, you're always going to have only one person initially who is a parent, either because they gave birth or because they were the one that got, whose sperm was used with a surrogate, and then therefore they get on the birth certificate. Or even with straight unmarried couples or straight married couples, they still might not be able to be on the birth certificate because they're not genetically related to the child that they set in motion to create, because the sperm and the embryo and egg are all from other individuals. So then looking at the broader picture, it is how do you establish parentage, particularly here in North Carolina, where we don't have things like you'll find in other states, which is like a uniform parentage act that determines how you figure out not only paternity but maternity. So there are cases where it's questionable who should be the mother. So historically, it was like a no-brainer. Of course, who's a parent is whoever is biologically related to the child, and even to this day, our birth certificate statutes only presume only that, of course, the gestational mother, the woman who gave birth, is of course also the genetic mother. I mean, we don't yet have any distinction between that, and that's not always the case. But so it was strictly biology, and then we started adding in some legal presumptions, such as if you were married, therefore even the husband was presumed to be the father, even if in fact he was not the genetic father, because we want to protect the family and we want to protect it and make the child for sure legitimate and all that. So that we started adding in some of those legal concepts. Where we're at now, we're striving to go to, and I think particularly following what you say is, we have so many situations where people are acting as parents. They have no legal rights, but they're acting, they're family members, they're acting as parents, and how do we give them rights and get them recognition? Because you're butting up against, our law does say that parents have a paramount, superior constitutional right to raise their children, and they have a superior right to anybody else, regardless of if they're the worst parent in the world and this other family member is the best. That biological parent is always going to have a legal advantage. So what do we do about those? And also the trend that we'd like to go in is towards the concept of intended parenthood, and that's like who should be parent is who intended to be a parent, who set in motion this medical technology to create this child, and should not that person, whether they're genetically related or not, but if they intended to be the parent, should they not be in fact the parent? And so that's where we're trying to go. In terms of second parent adoption, I mean, I knew about that when I got out of law school the year, I don't even want to tell you, but it took me, I knew about that then, and it took me about, I waited about 25 years before we even attempted to do anything here in North Carolina. I thought we had to wait for a critical mass, first of legal opinions around the country. There's more and more states were doing them. There was more and more opinions by the higher appellate courts in other states. There was a handful of states that were in fact enacting laws that specifically permitted second parent adoption. So I knew we couldn't be the leader in the country, so we had to wait for the rest of the country to do some stuff. And also, it was a combination of when you get out there in the real world, it's really not all about the laws. It's about the politics and the circumstances behind it. And one of them here was, for the first 25 years I practiced, we had the same clerk of court. And in North Carolina, your clerk of court is significant. He or she's the one that grants adoptions, unlike other states where it may be a judge. So finally, we had the clerk was retiring, and so it was a first opportunity to really impact who was going to be the next clerk. And there was, it's a little beyond my time right now to tell you about the work that we did in terms of influence who the clerk was that got elected, and he was quite aware of what the support he got from the gay community, because he had said he would certainly consider second parent adoption. So that sort of helped in the background too. So we started, the first one we did was in 2004. And basically, we just had to argue. Obviously, in North Carolina, there's no our adoption statute does not specifically say yes, you can do second parent adoptions. So we argued, you know, the intent of the adoption statute is what's in the best interest of the child. The statute says you should have liberal construction of the statutes towards that end, and you know, and that. You know, so we had all these arguments that we adopted from the other successful cases around the country. To say that even though it is not specifically in our statutes, that it is, the courts have authority, they can do that. There's many, many instances where the clerks can waive this or that requirement if it's in the best interest of the child. So we said this is just another one of those. And we did get our first, the clerks, however, given that this was sort of not a run-of-the-mill kind of adoption thing, they did basically transfer the cases up to a judge. So in fact, a judge was hearing these cases, and we did get the first judge here in Durham to grant a second parent adoption, and then we were off and running up until for about 6 years, and we, in that time frame, we did over 250 adoptions. We did in 3 different counties. We had 8 to 9 different judges who were willing to say, yes, we think we can do this. So all was going really well. And I think another thing was the education piece that occurred because of that. And going into court all the time, there was the mix of families were amazing. The just different races, different of the not only the parents but the children, and just seeing all the different kinds of families really was an education for the clerks of the court, for the sheriff sitting in that room, and for everybody. And I think that was a wonderful aspect of it too. I got to the point the sheriff would go get these little, you know, stick-on badges to give to the children, and you know, he was this just, you know, typical Durham redneck kind of sheriff, and he just got, you know, you get a cute little babies in there, and people start, oh, you know, these are just wonderful families. So that part was a great experience. But then unfortunately, what I had told every one of my clients was, you know, that, well, the legislature could come and validate this, or a court could, and what happened is all it takes is one couple to break up, and for the, as is the case in the Bozeman case, the biological mom say, well, despite the fact I consented to this adoption, despite the fact I asked her on the witness stand, would you ever challenge this adoption? Do you think this is a valid adoption under North Carolina laws? Yes, yes, yes. I mean, I knew they couldn't force him to stay with that, but despite all that kind of evidence, she said, oh, sorry, this adoption is invalid, and now that we're in a custody dispute, I don't want you to consider my partner in any way a legal parent, and you know, I'm the only biological parent, so I get total custody. And so that was raised in their custody dispute, and I had always told people I thought the worst case scenario was going to be, you know, that just the courts could stop us from doing them in the future. I just really did not think they would go so far as ultimately what our Supreme Court did, and said not only is this one invalid, but basically any adoption done this way would be invalid. So, and I'll come back to that in a minute. But basically, at the trial court judge found that that they didn't have jurisdiction to get into the issue of whether this was a valid adoption or not, and then when it went up to the Court of Appeals, we had a unanimous decision from the Court of Appeals that these adoptions could be valid, and particularly the Court of Appeals really looking at what was in the best interest of the child, and felt that, you know, that should really be a prevailing factor, and they sort of got it and supported it. Unfortunately, when we went up to the Supreme Court, I would say every time we've gone up to the Supreme Court on a gay related issue. We did that in Pulliam v. Smith about gay custody dispute with gay parents when that had been in a straight marriage for a while, that we lose, and we lose big. I mean, in the Pulliam case, which was basically, that case was gay father was raising the kids until, ex-wife discovers that he's gay and yanks the kids from him. And the court supported that, and basically that, in that case, they upset, like 30 years worth of case law, 18 cases regarding how you determine custody when there's a change of circumstances. And basically, in order to win, they had to really change the past law, and it really shook up the family law section, because it really took us back to the 50s, where, if you lived together with anybody of the same or opposite sex, that was so detrimental that you would lose custody of your kids. And so the same thing happened when we went, in my opinion, when we went back with Bozeman. In order for them, I think they know where they want to go, and they just got to figure out what's the law that's going to take them there. And so the only way they could invalidate this adoption was to say it was void ab initio, meaning void from the beginning. Therefore, therefore none of the adoption laws applied. Whereas we said that even if the courts, they had authority to do an adoption. That was clear. They were the court to do an adoption. Even if you a court makes an error, that just means it could be that it was a mistake of law. It does not invalidate the order. And so even, some courts, like in Kentucky, when they were dealing with second parent adoption, they said, we don't like this, you shouldn't have done it, you can't do it in the future, but there's nothing we can do about this order because the court had jurisdiction and they just made a mistake, and so we can't invalidate it. So our Supreme Court had to figure out how to get around it, and the only way to get around it was to say, well, it was invalid from the beginning, the court had no jurisdiction, and therefore it's all invalid. There were 2 dissents in the opinion, but basically addressing one that if you presume it's an order and it's just done improperly, a party can appeal right away within 30 days of an order being issued, but after 6 months, you can't even come in and attack it for any reason. So the dissents basically said, these statutes, these provisions apply. She can't come back. She's barred now from coming in and challenging it, even if it was an improper order. So that was where the dissent went. I do want to say real quickly, but there was a good part about Bozeman, and that was the second part that said even though she's not a legal parent as an adoptive parent, she is entitled to some custodial rights, and it reiterated these other cases that the Court of Appeals had decided in 2008 that how you determine a custody dispute between primarily same-sex parties where one is in fact the legal parent, but that basically said if you can show that it was a joint decision to raise that child, you acted that way, you held yourself out to the world that you were joint parents, therefore that parent could at least get some custodial rights. So that is, I think that was maybe a trade-off in some ways. So we did get that out of the Supreme Court, and that has been really helpful. I love to say we're even better than places like New York now about custodial rights for non-legal parents. So I created this big mess, so now Chris is going to come and he's going to tell you how we're going to get us out of it now.
It's certainly that easy, that clean. Again, I'm Chris. Thanks a lot for having me to do Outlaw. Greatly appreciate it. And a real pleasure to be on the panel with Caitlin and Sharon, and to echo things that both of them said. There are roles to play for so many people, be they non-lawyers, be they lawyers, and even for lawyers, different roles to play in this struggle and in this movement. When you think about the advocacy that needs to go on, the organizing that needs to go on, the public education with folks, that I think, one of the things that I took that was positive out of Amendment 1, and there wasn't tons that was positive out of it, was that there was a clear majority of folks who now favored civil unions in the state of North Carolina, and I would have been stunned to learn that at the beginning of that process. public education in a macro level, on a micro level with those sheriffs in the courtroom, but then legal work as well, whether it be direct representation or more impact litigation work. There are 8 million different avenues to contribute here. And the litigation that I'm going to talk about really quickly is basically litigation that is in the federal court that's trying to overrule this state court decision in Bozeman. And Sharon's experience is the experience of a lot of different progressive efforts in our state court system that you might have good results at the Court of Appeals, but good luck to you at the North Carolina State Supreme Court. But the reality post Bozeman is that married couples in our state can adopt, step parents can adopt, single individuals can adopt, but unmarried couples are not going to be able to jointly adopt, whether they're gay or straight. So we filed litigation challenging that on June 13th of 2012 in the Middle District of North Carolina. And the central argument in that case was similar to the central argument that was made in the state courts, which is that these adoptions decisions should be made in the best interest of the children, period. That should be what we're looking at, that we should not have, you put in this and you always get the same negative result, regardless of what is in the best the best interest of the children. And that's what the state of the law is post Bozeman. The first line of our complaint, I think, really captures to me the stakes here, and it's that plaintiffs are 6 North Carolina families. In a lot of ways, the law needs to catch up to the reality here. Gay and lesbian couples are raising children and raising children well in the state of North Carolina. And our bureaucracy supports and encourages that. So there really is no legal basis for saying absolutely not, under no circumstances is there going to be a situation where gay and lesbian couples can jointly adopt. So I think the first line of the complaint really does sum that up and hit on the reality in the state and how perverse the reality in the state is right now. I want to talk just very briefly, because when we talk about, when we get in law school settings and when we're in these sort of discussions, it's very easy to go towards abstractions and talk about legal principles, and I'll do that for a couple minutes at the end as well. But I want to introduce you to a couple of the plaintiffs as well in this case, because I think these discussions sometimes lose their human component when we talk about the law and its impacts, and that to me is a real mistake in this context. These stories need to be told as human stories, not as stories about heightened scrutiny, and not as stories about due process rights. So two of our plaintiff couples, introduce them real briefly. Terry Beck and Leslie Zanaglio, they're Morrisville residents. They've been in a committed relationship for 15 years. Terry's a staff recruiter at Duke. Leslie is the director of operations at a consulting firm. They originally wanted to just adopt one child from the foster care system in North Carolina. They got contacted by the foster care system that said that they had 2 brothers that needed a placement. So Leslie and Terry, said, well, we don't want to separate these brothers. We want to be able to keep these brothers together. These are brothers who, his father died when they were 5 years old. Mother has a substance abuse problem. They've been in and out of the foster care system throughout their entire upbringing. So DSS placed them with Leslie and Terry, and they were in and out of that house repeatedly during the foster care process, and was fully aware of the nature of Leslie and Terry's relationship, and did nothing to discourage the placement, foster care placement, or the subsequent adoption that took place based on that relationship. And that is a long-standing policy in North Carolina. Going back to 1991, our Attorney General issued an advisory opinion saying explicitly that sexual orientation should not be a disqualifying factor when we're talking about foster care and adoption placements. So again, we have this sort of don't ask, don't tell policy in adoption. We can do it, but let's just not talk about it in a real sort of open way, and let's not certainly have the law comport with what the reality is there. Subsequently, Leslie adopted these two brothers. They've really blossomed in that home environment. The social workers are, again, still in and out of the house on a monthly basis. During the adoption process, both parents were scrutinized to make sure that the child placement would be in the best interest based on both parents that would be raising them. So that's Terry and Leslie's story. And then Lee Smith and Crystal Hendricks, are a little bit of a different story. They're from Asheville. They've been in a 7.5-year relationship. They have two biological children that Crystal is the biological mother of. And they have a daughter and a son. Lee's a former school teacher. She now stays home with the kids. Crystal is a school librarian. This is a situation where, again, Crystal is the only one with a legal relationship to her children. Lee is a complete legal stranger from these children, no legal relationship. And the challenge in this circumstance is that Crystal's parents are exceptionally conservative and do not recognize Crystal's relationship with Lee or, Lee as a mother of these children. So what would happen, sort of toggling over to harms here for a little bit, if something ever happened to Crystal? The next of kin in that circumstance is not Lee, is not Lee's parents, grandparents who do have an active role in their grandchildren's life. It's, essentially what are estranged grandparents who don't recognize Crystal's relationship with Lee. It's very hard for me to believe them suddenly becoming the parents is in the best interest of those children. It's very hard for me to believe that is fair, given that Lee has been every bit the mother that Crystal has been in her children's life. So, we have some videos up online that I really encourage y'all to check out. Both Crystal and Lee talking about this circumstance, as well as Lee's parents talking about this. It's just very wrenching to watch that. So that's, harms don't get much more aggravated and visceral than that. But, there are harms throughout all of these relationships not being legally recognized. Terry and Leslie just spent $1,400 on an attorney to draft agreements to do what they could to protect their children, and you can't perfectly recreate all of the benefits that flow to the children based on having a legal relationship with a parent, but those agreements trying to sort of do the best that you possibly can. For example, making sure that Terry would have the consent to authorize medical treatment if Leslie were ever out of the state and the children were injured. She doesn't have a legal relationship with those children. She could be hard pressed to authorize what is necessary medical treatment for her children because that relationship is not recognized. We have clients where children would not receive Social Security survivor benefits. We have same with workers' compensation benefits. We have a veteran who works currently at the VA, who's one of our plaintiffs. Her children, she's not the biological mother. Her children also would not get military benefits because there's no legal relationship. There are harms sort of up and down the lack of having a second parent adoption regime in the state. So we've pursued two major causes of action that I'll talk about real briefly, one a little bit more than the other because I think it's interesting in the discussions that are going up to the Supreme Court in particular next month. But the first argument is that the due process argument that Sharon sort of briefly touched on, which is this fundamental right to family integrity and autonomy that courts have recognized time and again, is that the state is not going to without exceptionally good reason, get in the way of parents making decisions that benefit their children. Yet that is exactly what the state is doing here. Now, what the state of North Carolina says in response is there's no fundamental right to adopt. But I mean, that is sort of the most formalistic response that you can imagine, and in no way recognizes the reality on the ground that parents are not able to make decisions for their children. And those parents are gonna be parents to those kids. They were parents yesterday, they're parents today, they're gonna be parents tomorrow. And that is just the reality of the situation. The equal protection arguments on behalf of both the parents and children, but general thrust there being that parents and children are discriminated against because of their sexual orientation. And, you know, first off, we make a rational basis argument, which is, you know, what is the legitimate government interest here? That children's best interests cannot be served in any of those two cases, but any of the six families that we represent by a categorical bar on single and, in reality, gay and lesbian adoption in the state of North Carolina. That just cannot comport with the best interests of the children. Studies show gay parents are, you know, as good as straight parents. In some studies that I've seen show that lesbian parents might be the best parents, but I'm not a good enough expert to speak on that issue. But there's just no real apples to apples research out there that in any way deviates from that. But, you know, the key thing to me on the rational basis argument is that North Carolina allows foster placements, allows adoptions in gay households now. They've done it since 1991. When Leslie and Terry are adopting, they didn't, you know, have Leslie go take a walk down the street for 2 hours and disappear when DSS was coming into the house. DSS knew that they were placing these children with a gay family. And what they recognized in practice is what we can all recognize, that those children are better having two gay parents than being in the foster care system. And they're just denying a legal recognition that matches up with that on-the-ground determination that DSS made. What we also ask for is intermediate scrutiny, which is, we believe that there's a suspect classification going on here, that there's essentially what's behind these bans on second parent adoption is discrimination based on sexual orientation. And that the government can't come forward with an important government interest to rationalize the classification and the disparate treatment that they've engaged in here. And, this is, an argument that has picked up a great deal of steam over the last couple of years. We've been paying attention on this front. The Windsor case, the DOMA case that's going to be heard by the Supreme Court later this month, the Second Circuit accepted heightened scrutiny should apply when there are classifications based on sexual orientation. And, this is not a decision that was made by, the furthest left member of the Second Circuit. This is Dennis Jacobs, who is a George Herbert Walker Bush appointee. This is something that's building momentum. We'll see in a good test later this month about how much momentum it has. But we feel strongly that the government should have to come forward with an exceptionally important interest if they're going to deny second parent adoption. But we don't even think that they can come forward with any legitimate interest for denying second parent adoptions in our state.
Well, thank you all for really amazing talks, and hopefully lead to a great discussion. I just want to say, in response to some of the information just about, queers and lesbians of color in the state, my girlfriend is from Goldsboro. I am now literally helping to raise 2 grandchildren and 2 of her own children. All of these children are not biologically related to me. One is, my own grandchild is not biologically related to me, but is in my chosen family. And if you put us all together, we make one fine family, but you wouldn't be able to trace it on a tree. So we're raising quite a few kids in this state, and we're not legal in any way, shape, or form. So I just wanted to kind of put that out there. Questions from the audience? And just say your name if you would before you speak.
Hi, my name's Allie. I had a question for you, Chris. You kind of mentioned like using other kinds of documents to kind of compensate for this. How much can they do that? Like,
That's a better question for Sharon.
Okay.
You want to ask Sharon that question, not me.
Well, as Chris mentioned, you can do what's called a minor's healthcare power of attorney. You could do parenting agreements between the parents about how they're going to raise the children, and that if they break up, they're both going to share custody and stuff like that. You could do, there's what we call friendly custody actions. If you need a court order that says you have certain custodial rights, you could, like for insurance purposes is a big issue, that you can't get your child covered on your insurance policy unless you have some kind of legal custody right. So we would do them for those reasons, or as been mentioned, to give you better protection if there's grandparent issues, the grandparents coming in and trying to assert rights. So we can do all those things, but the most we can do is get custodial rights for that non-legal parent. He or she can never become a legal parent in this state, and therefore, as Chris mentioned, that the child, if she dies, the second parent, then that child doesn't get any Social Security based on that, doesn't get workers' comp, doesn't get all those government benefits. I mean, we can't give people government benefits, so no matter the most you can do, you're still getting a half a loaf.
And paying to get a half a loaf.
Yeah, paying, but not getting the other half.
I just had a question for Sharon. This isn't a legal question. I was just wondering what was it the woman in the case that went up to the North Carolina Supreme Court? What did she respond to some of the criticism from the community, being like, "You're really setting us back decades"? I mean, how do you deal with that as a personal conflict? Do you know anything about that? I'm just curious.
Yeah, I don't, she sort of ended up cutting herself off, of course, from the community because, I think she was getting such flack. In fact, she moved to another state, and it may have been, I think, her parents who were paying for it all or directing it. Her parents, I think, were more conservative, and we don't know for sure whether...
Was she young?
Huh?
Was she young?
Not, 30s, something like that. I think
Young from my vantage point.
right.
Old enough to know better.
Yes, definitely that. Which I think that brings up one thing I was going to mention. There is a document that's out there that national groups have put together on sort of custody standards that, like, just we in the community are going to agree that we're at least going to try to be better than the heterosexuals or something. Or not only, and when we have custody battles, that and it's not because not only can we be as bad as heterosexual parents can be, but we can even be worse because we can take advantage of the fact that the laws discriminate against one of the parents. So this is sort of this ethical standard that we want to adhere to, that we will not use the laws that discriminate against us or do not provide protection. We do not want to use them against each other. Trying to get a buy-in to people to start thinking about that. And then, like in this case, not only did that, you screw your ex, but you screwed every other gay family in this state. And, to think about those kinds of ramifications and then unfortunately there's too many people out there who are willing to do that, so.
I was just going to add, first of all, I love the idea of building a standard where we're of better behavior. But I think it's also really important. I can't speak to this specific person and what she was thinking, but I think we do have to look a little bit at root causes, which, like, it's very not concrete, it's very amorphous, but if we do look at, some of the consciousness raising and building that used to be in place in the LGBT community has been really eroded. So really getting our folks young and a sense of our legacy as LGBT people, basis of feminism, like some real basic building blocks of political analysis that can often led to having some kind of standard, so that it doesn't have to come to lawyers and would-be lawyers like yourselves being positioned to be like, okay, now here's our legal standard. There has to be actually some mechanisms where we're building an analysis where we're doing better and we see the ramifications for others. But then two, another thing that we see, in grassroots organizing is that this kind of stuff happens actually a lot, especially in response to isolation. What we see is that violence within LGBT communities, as one example, just general bad behavior, kind of situations where, folks like me who pass as straight, all of a sudden you have a breakup and you're like, oh, well, I'm not dealing with the level of day-to-day in-your-face oppression, so I'm going to go ahead and use my privilege, right, in this way that really hurts the other person, right, without looking at, do we have an ethical standard around that? Is there some kind of protocols and mores in the community where we're actually committed to doing better and differently? And actually part of the work that I do, like with the National Gay and Lesbian Task Force and other groups, is to actually try to call them like get them early. There's a lot of folks between the ages of 18 and 21 that come through those kind of national spaces and really start to talk with other femme-identified women, for example, or other folks who are passing as straight about some of that real early in, so that there does develop also a way where people aren't going to those kinds of extremes, because it's sort of a bigger question of where we are right now.
I also think that one of the things, and I'll be very brief, that we forget about, I look much younger than I am. I'll be 50 next year. And I was that generation that got the phone calls after college about HIV/AIDS. And I think we really do ourselves a disservice when we forget about all the people we lost, who were leaders in our communities, who could pass down all of this knowledge, who were out before, it was fashionable to be out, who wore high-heel shoes to the prom, and got bashed for it. And so I think that we've lost a lot in our community, and I don't think that mourning is quite over yet. And I think that's the reason why the ethical standards, the things that we might have shared with one another, also the way in which lesbians actually took care of, a gay male population at the early part of the crisis, and how many of them are still raising some of those children, right, who are now, of course, college age. So we have to think, too, about why those numbers are so high in our community in particular. So we have time for a question. Brandon, Haley, do you have anything to add?
I'm good right now.
Well, also I had something that was sort of along that Sharon referenced previously, but to me, sort of goes to the perversity of the Bozeman decision to a certain extent. Is on the one hand, this de facto parenting custodial rights that the majority extends to gay and lesbian families is a positive in a very practical sense. But from a legal standpoint, so much of the argumentation surrounding why gay adoption should not be allowed to occur is related to stability. And of course, not allowing marriage and then saying, stability is an interesting perversity in and of itself. But de facto parenting as a principle in North Carolina is only applicable when there's a family that's breaking apart. It's not something that a family can avail itself of when it's still together. So if there really is this concern about stability and this idea that one parent would somehow do better than another parent after there is a breakup, then the de facto parenting principle does not comport with that in any way, shape, or form. So going to what Sharon was saying, where it was seemingly a very results-driven decision, there seemed like they couldn't fully jump into the deep end on being unbelievably harsh and denying of the reality there. But in sort of that slight olive branch in the decision, it really undermines any sort of intellectual consistency that could be found for opposing gay parenting, for opposing gay marriage.
I guess just one brief question. You were mentioning how, the name of the biological parent on the birth certificate is, very uniform now, and this is what it's going to be. Is there any pushback on that? For potential surrogate, surrogate births and things of that nature.
Well, that's, someday we'll list the ACLU in another lawsuit, the birth certificates. There's a whole,
Get in line.
there's a whole, there's just the problems there, including, I'll just give you 2 examples of so when the situation, 2 women, one's eggs are implanted the other, and the other gives birth. So I got a court order. I was, oh yay, got a court order. They're both legal parents, send that to Vital Records, and they're like, oh, no. We're not going to put both names on, and not only that, but they said, and the name we're going to put on is the genetic mom and not the gestational mom. And to this day, the woman that gave birth to that child is not on her son's birth certificate, just because the state won't do it. On the other hand, I was surprised when I did get a court order. So I can get these court orders. It's Vital Records. That's the problem. Court order that it was a surrogate gay father situation, and so he was a biological father, so he gets on the birth certificate, and it was anonymous egg donor, so the woman who delivered, the surrogate, was not genetically related. So I got court order that only he would be on the birth certificate, and that, in fact, they did agree to do. So I was like, whoa, now we're a birth certificate with no mother on it, so that's pretty cool. But so they're still tied to genetics. If you can't, so 2 men, they're not going to let in a surrogacy situation.
Which completely refutes the science, too.
Yeah.
Because, you do give genetic material to your child as a surrogate in some way, shape, or form. I mean, they're finding that out.
And then why should an anonymous egg donor or sperm donor who could legally come back, years later and say, oh, that's my kid, and I worry what the courts would do because they're so still tied to genetics.
Well, I just want to say thank you so much for wonderful talks, and thank you for being a great audience.
Thank you.